Yes.
You are live.
We're live.
Okay. I'd like to call the meeting of the Legislative Committee of the calling together. Present are the committee members. I'm joined by all the commissioners, all the members of the committee. Seymour James, a member of the committee, is joining us, although we won't, doesn't qualify us for the quorum, but we have enough as well. I'm also welcoming Len Austin, the chair of the commission, who's joining us, as well as executive director Berland and members of the staff. Anything else I should say?
Only that both Commissioner James and Chair Austin are attending pursuant to Section 103-A of the Public Officers Law and the Commission's rules and regulations and resolution governing remote participation in extraordinary circumstances.
Okay.
Technically, since I'm an ex officio, that doesn't matter.
You still don't get to vote.
Well, I wouldn't get to vote as an ex officio, so there you go.
But you can speak.
Thank you.
So you're listening.
So I suggest that we approach this discussion with the following goals. We clearly have a goal to complete a series of recommendations for the next commission meeting, which is scheduled for the middle of December. May possibly be postponed to January, but there may be a number of things that we find some merit in that we really require more study, both how it can be drafted and what the potential implications on the staff are in terms of burden and its practicality. I think we should also keep in mind as this discussion goes forward, whether we want to in effect create a study list that we won't be able to finish for recommendation for the December meeting, that there's nothing obviously to prevent us from supplementing the agenda later on. So with that, I also suggest that we proceed, if someone disagrees, you look in details, all I was prepared before the last meeting. To go through first our legislative agenda and any comments that the participants had. Then the deferred items on the legislative agenda and the comments they had. And then finally, the new proposals that were offered. Is that satisfactory with everyone?
Yes.
Okay. So,
No, so just.
yes.
We can have that.
Okay.
We can let him spend that. Yeah, at the end of the meeting.
So with respect to the tentative agenda, with respect to our tentative agenda, as I listened and heard all the comments, there were really no critical comments at all made on items 1 to 7 of our legislative agenda. And so I don't think we need to discuss those. I do think that item 8 does require a discussion. Item 8 being what we did briefly discuss in the commission meeting relating to the sexual harassment issue. And so I think we can discuss this not just with respect to the sexual harassment, but the broader issue of whether this should be broadened to include all harassment. So who wants to start off that discussion? Jim, you want to start off?
Sure. I guess my concern would be that, sexual harassment and discrimination, I think, are serious issues and that they do impact an employee's or an officer's ability to perform their jobs or to fulfill their oaths. But I worry that the manner in which it's clarified or enhanced in the law could have a significant impact on the kinds of work we're getting and the sort of mission of the agency. And I say that, I think, because one, my understanding, and I'm not, an expert in state government, I worked in city government, but that oftentimes agencies have EEO and anti-discrimination officers. There is a central, in the executive branch office, where EEO, anti-discrimination and harassment complaints can be brought. There's the State Human Rights Commission, and then we would be in actual, in legislative language, a third or fourth entity that does that. Each doing sort of, one gives damages, one doesn't have any of, the agency EEO offices and the central office, I wouldn't think has any ability to award damages or give fines or anything like that. We would have a penalty and I just think without very careful consideration, it could become problematic.
Next, put it.
Oh, yeah, sorry. I would like to kind of understand, I don't know if we've looked at or we talked about this, how many of the cases that the New York City and New York State Human Rights Commission handle that are within our jurisdiction. So, right, I think that should be on our mini list if it's not there already of things to study.
I agree, and also if we could get that number for the state office that does these kinds of complaints.
Right, so I think,
From the Office of Employee Relations.
Yeah.
so I think we should.
But when, in the reverse, we can look at those instances in which we have received complaints that fall within that general ambit, and the extent to which there have also been corresponding matters before, whether it's OER or another agency, or in the tort system, in state or federal court, being litigated privately by the victim of the behavior. In those instances, and there are few, just as in those instances where the commission is addressing the same conduct that criminal prosecutors are addressing, we would typically, but it's a matter of discussion, it's a matter of separate consideration, not just for this committee, but for the commission. Typically, if a prosecutor, for example, so if the conduct rose to that level, legal violation, typically we would defer to a criminal prosecution in the sense that if a prosecutor asks us to let them proceed first, we would do that. We have concerns about the preservation of evidence, the fact that criminal prosecutions, and we've had some instances that this commission or prior commissions have been involved in where cases take years, criminal cases take years to litigate and end up in the U.S. Supreme Court. We've kind of learned our lesson. We can't always wait. Sometimes we have to preserve evidence. Sometimes we have to move more quickly while the iron is hot. We have also found that there are instances in which other means, and we left out, the agencies themselves that are dealing with behavior. So it's not always just OER, DHR, EEOC, or the tort system that are dealing with these problems. Often it's the employing agency having their own disciplinary action. It has not been, I don't want to say it's common, because it's not as if we have vast numbers of these cases coming in the door. it's not unusual that we're beyond the body of last resort for redress and for addressing problems that are occurring, for example, in the workplace. A disciplinary proceeding may fail because the requirements of the labor management agreement haven't been completely met. So time limit, very short time limit has been long, or something else has happened. Or a resolution has taken place that we don't feel, it may satisfy the workplace rules of the agency, but it may not, in our view, sufficiently vindicate the interests that are protected by the public officers law. Likewise, I don't want to paint with too broad a brush. It could well be the case. And it may be why, one reason, among many, why proposals are before us. It may be that other agencies don't, because of resource or whatever reason, don't attach the same priority to some of these claimed conduct violations that we will assign to them. So it's not as if we're the last, body in there in the sense of everybody else has it under control and we can sit back. We've found there have been instances where, there's criminal prosecution. There were other agencies looking at it. And for one reason or another, it falls to us to redress, not because the claim, based on the laws that we apply and administer, aren't violated, but because prosecutors or those conducting civil compliance matters don't think that either they have the evidence or whatever it is to show that the laws they administer are violated. So I don't think
What does that mean?
we should assume that that's always the case. Coming all the way back to your question, which I haven't answered yet, in terms of numbers, I've taken a very broad look at, say, DHR's caseload. It's very, very large. We don't yet have a breakdown. We'll have to try to find a breakdown.
It's very
How many of their 6,000 or so, whatever they're currently getting, last annual report of theirs I looked at, they were getting in over 6,000 claims as against 150 to 200 that we received. So there's, huge category difference in our workload. We don't know how many of those involve the public sector versus the private sector, how many, if they do involve the public sector or municipal, as opposed to state involved claims. And then we don't know how many, if we were to review them, if they haven't come to us already, and by and large, they probably haven't, and how many of them would implicate the limited number of statutes that we apply. So it's really hard to make that assessment. Worst case, we would have 6,000 filings, and then we'd have to figure out which were, potentially within our jurisdiction and which weren't. Were that to happen, just that process alone is resource intensive because we can't just, indiscriminately, and it's a bad term to use, just brush these claims away. We have to take a look at each and every one.
Is there a res judicata issue as well? If in fact the person denies the sexual harassment and the reviewing agency finds that the person is telling the truth, would we still theoretically go forward, assuming it was within our jurisdiction, to find that the person did in fact commit the sexual harassment? That's something that might happen and that we should be concerned about it.
Certainly, I would take the position the other way. There is case law that dealt with it. Collateral estoppel being applicable the other way around, where there's a finding against the individual, which may involve violations of other statutes. For example, in certain criminal cases, absolutely, it's guilty. But where the allocution shows a violation of the public officers law, it's an admission of a violation of our law. It's not. It's a different sovereign. It's a different jurisdiction. It's a different body of law. So we don't have the res judicata. Or in the case of criminal prosecution, it's a double jeopardy issue. We have the flip side of it, which is that they're bound by it in the violation of our law. On the other side of it, I don't want to speak for Brian and his team, but if if a hearing officer hearing a hostile workplace claim, for example, at the agency level, finds that a particular witness is not credible, that's clearly going to, it's not binding, but it's clearly something that we would have to take into account in deciding on the handling of the case. Couldn't ignore that in my views, but it would be part of the mix.
There's no choice of forum. Like if you can prosecute anywhere, you can prosecute repeatedly, and you can file a claim repeatedly right now. So you can file a claim with the
If we come back and clear it up again?
No, I meant in different forums. So let's say
Different sovereign,
Complainant.
right, a complainant. Like I don't think we do have that. I think we should, but it seems like we don't have it. Like if you can prosecute a claim at the New York State Human Rights Commission, and also open a case here. But there is no choice of forum currently, is there? So nothing prohibiting somebody from bringing it and repeat it.
Well, nothing is really a broad way of looking at it. There's no statute that would prevent an individual from filing a claim with us, filing a claim with EOC, filing a claim with the DHR. I understand you practice at DHR. Anybody who files a discrimination claim, certainly an employment claim with DHR, automatically DHR files an EOC claim on their behalf.
That's right.
If they're,
You only have to file in one place and you get them both. That's right. Interesting. So
yeah, there's a lot of batting back and forth at that level. But we don't know. We don't, and it's quite possible we won't know until there's some change. But the broadest statement I can make is we don't turn those claims away, and we haven't had challenges to our jurisdiction in those types of claims. So claims of workplace harassment or discriminatory behaviors that are manifest as violations of the public office. I'm putting a lot of qualifiers in there. We still need to have, our jurisdiction isn't just universal. It's limited to the statutes we enforce.
That's the concern that it becomes an invitation to maybe what people perceive as a broader universe of EEO employment complaints.
Yeah, and the thing to be cognizant of is the request. It's not for jurisdiction over sexual harassment claims. It's for clarification. We have jurisdiction over sexual harassment claims in the state workplace by state actors. I mean, the elements have to be there. We have that. And I don't think any ethics commission in New York State has ever eschewed that kind of jurisdiction. We're asking for the clarification because it's one more instance where, and it's the nature of the beast, it interrupts the flow of enforcement. And what we're about is not so much enforcement as compliance. We want people to comply with the law. And one tool for getting folks to comply with the law is to show that we have the capacity to enforce the law. So if you don't comply, you're going to end up on the wrong end of it. It shouldn't be at an abusive level that individuals who have the resources, when they're faced with an enforcement matter from us, can interrupt it, raising jurisdictional challenges in court. So having the clarification statutorily will enable us. It's not going to prevent the Article 78 from being filed, but it will give us a readier defense than having to re-argue each time whether it's ripe enough and whether jurisdiction lies. It's expensive for us, delays the process. The one case that's out there that is a recent article in the papers about us and about the commission, about the case. That case has been around for a long time. It's in court for the second time. We still haven't gotten to the hearing. Article 78 requires a certain level of ripeness. So
I don't want to interrupt you, but I know, I think Len has a comment. I know he has to leave in a few minutes, so you want to say something?
Actually, I was going to say I have to leave now. My mediation starts at 2:30. But thank you. And if Michael, you could give me a report later as to what happened, we will go forward. And I thank the staff for being available and helping us work through this. Have a great weekend and a happy Thanksgiving all.
Same here.
Thank you. Seymour, did you have a comment or question about any of this?
No, the only thing that I would like to say is that, I mean, I agree with the steps that we need to take, but I also believe that we cannot limit it to sexual harassment. If we do sexual harassment, we also need to do discrimination. Because otherwise we're suggesting that the harassment is significant and covered, and the discrimination is not.
I agree.
And the staff, that I invite comments from the staff. I see that Keith is here and some others. So any of you have any comments, please don't hesitate to express your views. And then I think the next question is.
Well, could I just, I have a comment to Commissioner James's point, and I understand that concern. And we're in the same position with respect to sexual harassment. Staff's very strong view, it's been the commission's view, continuing view, that sexual harassment is within, where it expresses, it's manifests, it's a violation of public officers law. It's within the commission's jurisdiction, and we've always acted on that. Again, we've never turned away a discrimination claim of any kind that involves the violation of the public officers law. We've never felt, in the prior commissions, I believe have not felt that asking for the clarification for sexual harassment, which goes back, so far as I can tell, at least to 2017, and it may go back earlier than that. I don't think there's ever been a view that by asking for clarification, the commission was somehow suggesting that it didn't have jurisdiction without it. And whereas we have ended up in court, and always back, prosecuting the case after whatever spate of litigation over it. So we retained jurisdiction in every instance I know of. Nonetheless, we asked for the clarification to avoid that. If we were having a similar experience with other forms of discrimination, then we'd be fine to ask for it. And then I would be concerned too about the flip side. If we're asking for it because by not asking for it, there's a thought we don't have jurisdiction. What if we're unsuccessful in obtaining such legislation? I mean, I would argue, because I think it's correct legally and factually, that all we're asking for is clarification. Even there, it has no significance. And that's all that would be added.
You're not just talking about sexual harassment.
Yeah, I mean, all harassment. So we're getting to that area of implications that I think have no weight, and I think we could make quite clear. But having said that, I should say I don't think anybody in staff at all disagrees with this. If we're given jurisdiction explicitly over whatever subject matter we're given, we will carry it out. We just ask that to the extent it impacts our workload, that would be given the resources, because the worst thing that could happen would be to get those 6,000 DHR claims as an example. And that's the extreme.
Or 2,000, well, or 1,000, whatever.
Whether we have a tenfold increase or 300% increase in our workload, it will slow us up unless we have a lot of resources. And it's not helpful to the system to take an issue that another agency is having difficulty managing and transferring it over to us and putting us in the same position and now having two agencies that don't have the resources to handle all the claims. But at this point, especially, We will as quickly as we can. As Commissioner Cardozo said, this is going to take a little bit of time to finalize the agenda in any event. We'll get whatever information we can from DHR to see what percentage of their workload. And maybe some of the groups that have proposed this expansion they haven't seen the information yet from them, what they think will come over, but it would be helpful. They participate in that. They may have some insight in it, and they may be able to respond more quickly. If this is going to be part of our legislative initiative, as opposed to our supporting someone else's, we're going to need that ammunition in any event.
Well, may I suggest then that we put this on our to-study list, that it's not included in our legislative agenda that we're going to recommend the commission approve in the December, but that we put it on a study list so that we could then, in effect, have a supplemental agenda item and that item is studied. Does that seem consistent with what we should do? I'm just speaking for myself when I say that. But that means that at the moment, item 8 on our tentative legislative agenda would be because if we finalize it, then we're going to include it in our December recommendations.
Well, again,
I'm just, just asking, does that create a problem that we've withdrawn it?
Yes, it does. With some of our stakeholders that we've talked to, they do not want to see that removed off of the list for the sake of the whole package that you guys want to look at. That was a concern that was expressed.
Thank you, Emily. So we have to decide now, do we want to approve this? Keep it on the study list also, but include it in the tentative legislative agenda. Am I reading things too narrowly, or is that a?
well, I certainly feel very strongly about pressing ahead for the clarification, but we've been pressing ahead for years now with the clarification and pressing ahead with the enforcement proceedings because we are comfortable, we are confident that we have jurisdiction.
So I think we talked about just tracking the language of the state law.
Yeah.
That includes everything as our amendment, no?
Well, no, what about simply saying, keeping on our agenda, but also adding it in effect to the study committee? Because the agenda is the beginning, not the end of anything anyway. So we would then be prepared when we're discussing with the legislature to have further arguments. So is that fair to say that we should leave item 8 the way it is?
Yes.
And I don't have a printout of what you're looking at. Yeah, okay, item 8.
All right, moving on to item 9, which is the open meetings law. The one comment that I think you should pause on is that the Reinvent Albany group, while agreeing with that, wants to expand it to include not just advisory committee meetings, which is the way we've drafted it, but all commission and committee meetings, not just advisory things. Where we drafted it is, we would have an ultimate decision. But they added to their proposal, which we do not have, a requirement that there be one physical location that the public could attend, which in our instance would obviously be one of the commission offices.
With at least one member?
With at least one member, yes. Oh, no.
That I wrote this up, I found the email so I could, circulate it again. With that suggestion in it about, let's see, but I don't think it should apply to commission meetings. I disagree with that.
Well, commission meetings are, right now, the commission meetings are open to the public.
Right, I think it should stay
Yeah,
commission meetings. I think it's for committee meetings where we don't make any decisions, and I think the literal reading of the statute allows it. It doesn't really apply to committees. I think it was more the way it was interpreted by courts that made it apply to committees, right? Because the way I read the plain language of this, of the open meetings law, it seems to me it shouldn't apply to committees, you know. But it doesn't matter because that's how it's been applied. So
Yeah.
I think just saying, I think that's right, that if we could have committee meetings where there's one person present in some place that's open to the public or the two locations that we have, I think that should alleviate the concerns that people have.
That would mean that if we're having a committee meeting, one member from Buffalo, one member from Albany, and one member from New York, one of those three members, if it's just a three-person committee, is going to have to attend physically in either Albany or New York.
And not even just the committee. I think it's what it should be even just to have, an officer or a person, a staff member, or, whatever level they want to make it, but I don't think it has to be a committee member.
But
present.
I just wonder whether, as a practical matter, given where we are right now, Reinvent Albany has basically agreed with us. They want to make it broader. They want to add a condition which we didn't have. It seems to me that is, as a practical matter for negotiation when we're having the statute. My personal recommendation is let's leave it the way it is. Let's encourage Reinvent Albany to continue to push. And we can then have this discussion.
Leave it as it is, meaning what?
When we propose.
The proposal.
And let's have this further discussion when we're sitting with a couple of legislators on the committee, rather than getting bogged down in these details.
Yeah, and while the proposal is broader, it would be permissive. So a commission wouldn't be required.
Right, not to be
Not
virtual.
to-
You
not to
can,
meet.
we can see each other if you want.
So I suggest we leave our proposal as is.
Okay.
Who is
Yeah,
it?
I agree that we ought to stick with our current proposal. If Reinvent Albany is successful in getting their proposal passed, it would accomplish what we need. But in terms of what the needs of the commission are, I think we want to focus on enabling our committees to meet virtually.
Okay, so I suggest then we have now agreed that all the items on the tentative legislative agenda should be included in our final legislative agenda. And we should now move on, I suggest, with the comments we've received on the deferred legislative agenda, to consider whether we want to add any of those deferred items to the final legislative agenda. That first item, I think we didn't finally determine it, but if the public official misstates what we say, or what are we going to do, we get a chance to review or discuss Michael's draft opinion, and citizens took some exception to it that I don't quite understand. But Michael, do you want to start off on that discussion?
We probably should be named. Yeah.
I'm sorry.
No, that's
Michael did tell me that he had some reason.
everything is a team effort. The concept of the advisory opinion was offered as an interpretive way of addressing this open question of whether, under the current version of the statute, which doesn't have built into it any exception except for really dire circumstances, public necessity, fraud or emergency, where the commission can breach the confidentiality that surrounds guidance. And the motivation for that, obviously, is to encourage individuals to come up to us for guidance rather than sort of cooking things up on their own without asking. The prior stance was somewhat looser. It didn't have a specific provision, and their JACO commissioners adopted a resolution allowing them to correct misstated guidance. It's not entirely clear whether this commission has the same latitude or not, because there's nothing specific. There's a minor change in the presentation of the statute. It seems, there's several alternatives that have been put out there. Some of the good government groups took issue with the prospect of, instead of addressing the specific misstatement, putting out general guidance, just clarifying what the actual rule or principle is. If the commission is concerned about misstatement. Another would be simply to get legislation allowing the commission to correct misstated guidance and defining what would constitute misstatement. The other option was to have an advisory opinion or some other formal instrument from the commission, making clear to the public and those who are receiving guidance that it is the position of the commission that if a recipient of guidance misstates it in a way that's material to the commission reserves the right to make a corrective statement. And the advisory opinion presents a slew of case law dealing primarily with admittedly attorney-client privilege, which has statutory stature in New York and in other jurisdictions, and other instances of contractual violations, and some statutory situations where there's confidentiality. But it's offered as one alternative way of addressing the problem, particularly if we're going to have a robust legislative agenda. I think it would be helpful to have at least that one item off it so that we're not having to present that as well. And it's a little bit different than, not totally. Most of our proposals are aimed at increasing transparency and improving the ability of the commission to achieve compliance and enforcement if necessary. This is a little bit off to the side, but not a lot, because misstatements of guidance can be misleading.
Want to add to that, Michael?
I think that was plenty.
I think, we didn't get an opportunity to take up the advisory opinion at the last meeting. I guess it was deferred until the December meeting. But if in fact we're going to go forward with that advisory opinion, I agree with Sandy that it would make sense not to include this in our legislative agenda, but to, if in fact we decide that we don't want to do that, then we have to reconsider. But at this point, I would suggest that we not include it and rely on the adoption of the advisory opinion.
I agree. Okay, so that will not be included in the tentative agenda. The next item is item 2. Should we endorse a legislative change expressly adding discrimination claims? I think we've already discussed that. I don't think we need to discuss that anymore here. The third item, should we support legislation requiring that lobbying filings clarify whether lobbyists support, oppose, or take some other positions? We didn't have that on our agenda. Reinvent Albany says that 5 states have this requirement, and Citizens Union endorses this as well. And I think our response is, well, they have the requirement, but we don't know whether that's been at all meaningful. So do we, given where we are today, do we want to add this to our agenda, legislative agenda?
I think Carol said too, but maybe we should get that study first, right? Of whether or not it's been helpful.
Carol?
I think this is more of a judgment call at this point. We could, mimic the proposal that was given to us. I'm happy to do whatever you'd like. I do wonder about how meaningful the categories will be, given that many will be in the middle. But I'm happy to do whatever you if this is something you want, we can draft it up.
Well, I think
Sandy
we
wants-
have, as I understand it, the staff has more than enough to do if we're going to end up with meaningful information. Then we want to do something about it. But I thought your point really was until we know.
Whether those states get any benefit from it at all, from that law. So that's on the, I think that should be on the study list.
Okay.
But that's
Can I
my,
just make a comment? Can I make one comment? I just want to give you feedback that I've heard from several reporters this week that this is something they would like to see because they would find it useful. So no fewer than 3 or 4 just alone this week said that. So just FYI on that.
And NYPIRG as well as Reinvent Albany and Citizen Union were in support of this proposal. Some variation of it, yes.
Yeah, well, what we need to do is to go back to the groups that are promoting it, and because there are different alternatives, and we know that from our own study of the statutes, we know they're out there. What their experience is, or has been in other states with the various kinds of designations.
So then shouldn't we leave that off our agenda for today and ask Carol and her group and whoever will be doing it to study this a little more, to touch base with Citizens Union and so forth, and perhaps then add it to the agenda depending on what she finds, 2 months from now. Is that a fair way to put it?
or can we find from those states?
Yes,
What, right,
So
okay, what the
just
balance is,
consider-
okay, and what the language is,
Okay.
and the category.
If I'm moving too fast, don't hesitate to interrupt. Just we have a long way to go. Right. The next item is proposed by, again, the 3 good government groups to disclose lobbyist fundraising. Should we require that there be such disclosures?
I think there should be, but I think the argument was that it's already available, but it's just not all in one place, so you would have to search around, right? That's the issue right now?
Yeah, I mean, somebody interested in finding that out would have to look at the campaign finance filings that are all available. The data is all available online from the State Board of Elections, and then they would have to.
How big of a lift is it for us to do this? How hard would it be?
For somebody who wants to see that information.
I think it's valuable information. I have tried on occasion to see what lobbyists were contributing to whose campaign, and I wasn't able to find it. That was before I joined the commission.
Yeah, I mean, we are actually, Carol's group's working with Board of Elections because under the campaign finance, recent finance laws, in order to get matching funds, you have to show that you're not receiving contributions in excess of a certain amount from various kinds of individuals, including lobbyists. So we had to provide information to them, make accessible to them information, identifying lobbyists. I may not be getting the intricacies exactly right, but they're looking at that. So they're pulling that data into some extent. We have extended an offer to, and now we Division of Budget Approval to bring in a research data analyst. One of the things she will be able to do is to look at how difficult or not
It is
to pull those databases together. So assuming that gets approved, so we'll know how doable that is or isn't. And if it's not overly complicated for us to do, then it wouldn't be overly complicated for others who are interested in doing it to do it without having to change lobbying statute, change definitions, change all kinds of requirements in the system.
Is that what, like, that's not available on the open? Is that the website that we put everything on? Well,
The data is there on OpenNY, but the data is also, you can also search through, and there are ways to develop protocols and reports to search through our home data on our lobbying application.
so but right now you would have to go to both. You'd have to go to the election finance disclosures and
You would.
look at our lobbying thing right now.
Well, you'd have to look at who the lobbyists are. You'd have to look at what they're lobbying for. And then you would be looking at who they contributed to in the campaign finance database.
And
But-
clients, right?
And
As
clients.
well.
Right, so we're trying to make it into one, that we could look at it in one place. That's the
But
suggestion.
there wouldn't be, that'd be too much of a burden on at least New York City lobbyists, for example, to have to,
Who are already
who are already doing it.
Right. Would this cover bundling or no?
It would depend on the statute.
That's right.
It would depend on the statute, third party, all those things that go on that we don't have expertise.
Right.
But the Board of Elections, both in the city and in the state, does have that kind of we do have that kind of expertise.
Well, then let me ask again, is this a question? I think we all sympathize and agree with this in concept. But we're a little bit concerned about burden on the staff. Is this something to put on our study list, so to speak, rather than on the immediate agenda?
I think so. I mean, we have been, as I said, we're bringing in a research data analyst.
Right.
Once we're successful with that, we'll have a very sophisticated capability that will be able to allow us to do a lot of things. This is not the only thing by any means for bringing her in.
And
To
my
work on
thought
that,
would, broader is better. If we could get it bundling and things like that, that would be great. But how much work would that be? How much expense would that be?
I think it would be extremely helpful, but
How much
yes, we won't know yet,
So is that a fair summary to say, put it on our study list?
yes, I think so.
Yeah,
yes.
and we would also have to, I mean, it's not even, Carol, you will have much more insight into this than I will. There's an IT dimension. Adding campaign finance, and now we're talking about really getting sophisticated with bundling and third parties and all sorts of other things. But think through what enforcement powers we would need, in addition to what we have, if any, to do it. I'm thinking this would be a big thing for IT to take on, for ITS.
Yeah.
Yeah, and at some point, I don't know if there are limits that this would be challenging on our architecture of our
Emily
system.
has a hand up.
So
Emily has a hand up.
oh, Emily, please.
Sorry, that was an old race.
Oh, okay.
What's this, what do you hear about this proposal? How is it something people are?
Yes, please, Emily, don't hesitate to jump in.
I have not heard anything from reporters on this particular proposal. Well, just the stakeholders.
Oh,
And the fact that they want lobbyists to report this information doesn't necessarily mean it has to be reported to us. It can be reported to, for example, the Board of Elections.
right.
So,
Well, I think
Yeah,
the
I
two
would
issues
just
are, one
add
is,
that- Sorry.
I mean, contributions to political candidates is one thing, but aren't we also concerned with contributions to a non-for-profit that is going to do lobbying and it in support of the lobbyist efforts? Am I mistaken?
It's a separate issue.
It was a separate.
I think what Seymour's saying is it's related.
Yeah, that's right. I think it is.
It is related,
Right.
yeah.
Right.
So it sounds like we're not quite ready to endorse this yet till we have
Well, we're gonna get that information from you, so I think that's gonna help.
Yeah, and there's additional reporting that's been suggested too. Not only campaign contributions, but consulting work that's being done by large lobbying firms. So multiple capabilities and contributions they're making to those efforts. And our position absolutely is more information, the better. Anything that contributes to transparency is something we absolutely support. But for us to take it on, we really would have to have a better understanding of a budget and what it would entail. And again, a lot of it comes back to if the information is already out there in a way that's accessible, albeit you may have to go to multiple sources to get it.
But it's easy, I
Overall,
know it's not easy
Yeah,
to get.
it's
Well,
having multiple reporting of the same information and burdening multiple agencies may not be the most efficient way to.
I suggest again that we put this on our study list. I do think we should keep in mind that how we're going to communicate this to the public, we may want to say, the more information, the better, but we have to be practical. And so while we endorse this concept, we're not ready to urge its legislation until we find out a few more facts and a fair way to put it. Okay, now, unless someone disagrees, off of our deferred legislative agenda, those are the items that generated comment. But there were 3 or 4 additional proposals that were made that I think we should discuss. Before we move there, any other comments on the deferred legislative agenda items? Okay, so the one proposal that intrigues me is the proposal that lobbyists who lobby regarding nominations or confirmation of nominees should be required to disclose and file. That was endorsed by the key government groups. And we want to get on board on that issue.
One thing we could do on this too is not put it on our legislative agenda, but when the bill is proposed again this year, and if we take a look, and as long as it's not retroactive again, just support it and say, yes, we would support that bill, but it doesn't actually have to go on our agenda.
And keep in mind, if and when some of these bills actually get traction and start moving through either of the 2 houses, we are often routinely, that might be contradictory there, we are often asked by the executive chamber to comment on legislation if it looks as if the bill may wind up on the governor's desk for her action. So there are multiple occasions by which we are in a position to offer comment on pending legislation.
Thank you, Keith. That's a very good point. So I think we don't need to take a position on this now. Is that a fair way to put it? And again, I don't think this is one that requires a lot of study on our part, but we should keep it in mind.
Yeah, I mean, the one thing to keep in mind, and we have commented on prior legislation, is of course, if it contributes to transparency and there's a need, we support it. You know, what its impact will be, will depend on the scope of any legislation that moves. But it will impose cost because if it's broad, there are, Carol, do you have in mind the total? It was hundreds of nominations that potentially could be the subject.
Yeah.
Yeah, I believe it was like over 200. It's amazing. You just think of it as the big ones, right? But there are many.
Right.
Yeah, so we don't know.
So we could just come up with a list.
Yeah, but it's many positions, and the way the lobbying application is structured, it's not open-ended. When somebody is having as a subject of lobbying a particular position, they would have to name who their lobbying is directed at. Correct? It would be the position, Carol, or maybe even the individual, depending upon the nature of the process. So we'd have to make that programming change for that sense.
Right, and then we would probably, add the name of the offices that you need confirmation for, and that wouldn't, assuming we can get that information, I'm sure we could. So we'd have a drop-down list for that, but then yes, who are you lobbying to get someone in that position, whatever that position is, we would have to build that into the system.
Isn't there a distinction between nominations that require Senate confirmation, such as judicial confirmations, and simply executive appointments? Will you be talking about both? I'm considering appointing Joe Smith to be in charge of the such and such agency. There seems to be a distinction there.
Yeah, the proposals that we've seen address confirmations. So there's been some sort of nominating process, and then typically in front of the Senate. There was also the distinction drawn we don't have figures between, confirmations, using that generically, that are approved by a motion in the Senate, which don't, because it's a motion, don't fall within the definition of lobbying. And those that require a resolution, which then would fall within, am I doing it correctly, Carol? Within the definition of lobbying, yeah.
Yeah.
So that was the proposed anomaly, right, if you will.
So again, I suggest we defer this.
Yeah, we can look at that.
Okay. Okay, the second new proposal that interests me is that small lobbying firms should not have to file bi-monthly, but just twice a year because of the burden that it imposes on them. Some express this in terms of the number of employees, some in terms of the budget issue. It struck me that philosophically, this sounds like a good idea, but I don't know about the mechanics of that, my personal view.
Another alternative might be quarterly, because I don't think, Carol didn't think that was a good idea to do the twice a year, but maybe quarterly is less, right? It's what, it's.
But it's really a question, do we want to get into this issue? Then, if you're spending $1 million a year on lobbying, that's one thing. If you're spending a smaller amount, where are the cutoffs? Argue about where you draw the line, but should everyone be in the same category?
And remember, this will result in less timely transparency, right? If we're delaying when people have to file, you might not know until the session's over that these people lobbied that session. So just keep that in mind.
Yeah, correct. So obviously, the less you report and the less timely you report, the less transparency. I'd also be curious to know really what the burden is. There's a filing fee, so a registration is $200 a year, or if it's the second half of the biennial, it's $100. And, that's over the course of 2 years. So it's either $200 or $100. And then if you're a client, it's $50 every client semi-annual report. But there's no fee for the bi-monthly report. So we're not talking about large fees to, submit your work. And I don't know how, I'm wondering what the burden is with filling out the disclosures. Because
Maybe we could reach out to these groups, Carol.
You won't have, I'm sorry, go ahead.
I was just saying, maybe we could table this one and just reach out to the groups to find out what that burden is and report back, because 3 of the groups said it, and I'm sure we could have a conversation with them about it.
Mm-hmm.
I assume that I might be wrong. If we don't know for sure, even more reason to put it on the study list is that they were trying to target here small not-for-profits that don't have outside lobbyists. So therefore, somebody on a small staff is doing these reports every 2 months and taking, a fair amount of time away from whatever their service provision is supposed to be. And that does seem also intuitive to me to make sense. But if we're not sure that that's the group and that they have that hardship, then we could put it on the study list. I mean, I could sort of go either way on this.
Yeah, I mean, we don't know if it's that or if it's small organizations that are hiring somebody on the outside, and then they have the expense of doing that. So it could be one or the other or both.
That's the question.
Right, and I think we should also keep in mind Keith's point that we don't have to endorse each of these legislative proposals. We can, if there's legislation introduced. So at the moment, I think we should defer to the study group. Okay. The next one, which we've sort of touched on before, require lobbyists and their clients to report payments to community groups, which NYPIRG and Reinvent Albany endorsed.
Yeah, I had a question on that for Carol. Ordinarily, if those community groups are involved in some form of lobbying and they're receiving payments, depending on, whether the source of funding rules are triggered or beneficial client or whatever, there may well already be reporting.
Correct.
Not-
The distinction that is important to know, though, is that a 501c3, so your typical not-for-profit, they don't disclose their sources of funding. They're exempt under the law from disclosing their sources. But if a not-for-profit is a C4, those entities, those not-for-profits do disclose their sources, again, if they hit the threshold. But Sandy's right, whether it's a C3 or a C4, if they're lobbying and they hit the $5,000 threshold, then they have to either, file as a client or file as a lobbyist and disclose their activity. So you'd get the activity, the lobbying activity. You would not get who's funding a C3 because they are just exempt from source of funding, but you would for a C4. I don't know if that helps.
No, it does, and there are constitutional dimensions too, with respect to disclosing sources of funding, potentially for C3s. So I wonder if we're going around. Well, there's a policy of not requiring them to disclose their sources of funding in any event. You'd be changing that.
If it's a C3 that under the federal law is exempt, we could change that by law.
Well, we have exempted them from these. We have
Right.
statute exempts
State
source
or
of
federal?
funding. State.
Oh, it's state.
It's state, correct, Carol, is the state statute.
The exemption from the source of funding disclosure for C3s is a state law. Obviously, whether they're a C3 or not, and all the whatever the lobbying and not lobbying benchmark is, that's a federal thing. But from our point of view, the source of funding law, the New York State source of funding law related to source of funding exempts C3s.
But don't we want to know what the lobbyists are actually doing? So identifying the funds that requiring them to describe what they're giving to 501c3s would help us to know what they're doing rather than impose that burden on the not-for-profit.
What would we be asking a lobbyist to tell us?
If they're contributing to a not-for-profit, for that not-for-profit to lobby. Is that, right, that's what I thought about. Are they just talking about any contribution to a not-for-profit?
Yeah, we don't know, and there are rules on reporting co-lobbyists and lobbying expenses. We would have to look at, I'm not entirely, we don't have all the facts. Not sure what problem exactly is being identified here. I know the fact pattern, it's been in the newspapers that they're talking about. And it may not be what we would call lobbying activity anyway, if it has to do with licensing, for example.
Or, sometimes doesn't, I don't say a smart developer, but, they
Right.
they and their client give money to various popular community causes just to sort of generally quell opposition. And they're not asking those people to do anything other than be happier.
Expecting them to not, raise the funds.
So I don't know if that's what they're trying to get
So it
at.
sounds like this is not something put on our agenda, and somebody can follow up with NYPERG and
Yeah, we can follow up with them, and if they have a bill that we could look at, so we have a better idea
Of what exactly we're trying to target, yeah.
what the implications. It may implicate lobbying, it may not, as you say. Look at what it is.
Okay, I think the next few are probably not things we want to pursue, but
use independent budgeting for all enforcement bodies. That we should draw our own proposal on that score. It's what Reinvent Albany proposed. I think under the existing law, we already have the ability to submit our budgets in some way, don't we, Sandy?
We do, we're called upon annually to submit a budget.
I think this really doesn't apply to us at all.
Well, there's been back and forth for quite some time about whether an ethics agency, rather than having its budget each year determined through the political process, instead should just have an automatic percentage of the state budget so that its budget can't be touched arbitrarily. But you know, the devil's in the details. Does the formula may be helpful, it may be unhelpful. It seems to be more transparent to do it through the ordinary budget process. There are a number of reasons. But the current process is an integrated part of the law. Let me put it that way.
So it doesn't sound like this should be high on our,
No, you know, again, it would be helpful to see a proposal, and then we would have to study and see what the numbers would mean for us. And you know, certainly we wouldn't want to be locked in. If we end up with a large increase in our workload as a result of one or more of the proposals we've addressed, being locked into a formula might not be a good thing at that point. And then we might also have to then figure out how to change in the formula made.
So if we put this on our study list, is this something that we may also want to see about what's happening in other states and whether in fact their independent budgeting is utilized and how effective it is?
Yes, I know some work was done a couple of years ago on that, and maybe it needs to be updated. But I know there was some groups that had looked at that as part of, not us, but outside groups that looked at the relative success of proposals like that in place. We can do the study list, yeah.
okay, the next item I don't even quite understand. Urge non-New York management staff be required to file annual financial statements.
Yeah, I don't get that either.
I don't understand. I'm just quoting from the letter. I don't sure I even understand.
I think it was a misunderstanding, Michael. You saw it. What constitutes the threshold and how the threshold is determined for filing. I think the individual was pointed to that and felt that there were some individuals who were earning above the threshold who weren't required to file. The way the statute is constructed, policymakers cannot be exempted from filing, but threshold filers can, either by category in a particular workplace or based on individual circumstances.
You can apply for an exemption.
They can apply for an exemption, and there are criteria they have to satisfy. And there are some number of standing groups that have the benefit of a position-wide exemption.
So everyone above the threshold has to file unless they get
Correct.
the exemption.
Right, and policymakers cannot get an exemption.
Okay.
That sounds like something for us to have to get involved in.
We administer it. It was a minor change in CSA versus F.
There was a period where the two didn't, but that's over.
So we can skip this. Yeah, I forgot one other. Urge COLA to meet with New York City counterparts to review their rules and try to harmonize them. I think that really goes to a process of, do we interact with,
I mean, I think it's addressed the lobbying, and Carol and Megan do and have had meetings with the city lobbying bureau.
And I know there was a representative of the lobbying bureau at our public hearing.
oh really?
Yes, because I worked very closely with all of them for many, many years, and they were there, they were very interested, and I know, they would sit down anytime, with us, so.
But that's not a legislative issue, that's just a process.
Right.
No, and it's something we do. Carol and her group have done that. It's gone on for some number of years. Actually, we've had to coordinate with them from time to time when there is change because the impact.
We may want to talk to them about the one or two items on our study list that they, for example, that they're doing already with lobbyists, campaign finance interactions.
It's not a legislative.
No, so I wasn't implying that was.
At least as I read all these proposals, that was, I dismissed some, I didn't spend too much time on one or two people who you may think of that,
You did a very nice job with it.
but I think that's all four parts. What I do suggest is that we create a summary of what we've just decided and in effect have sort of 2 or 3 separate lists of study in terms of priority. And I'll be happy to draft that and then circulate that. But I do think that we have to think about this, working with Emily. What are we going to say to the public? This is our this is our legislative agenda that we propose to be adopted in December or January. And how do we answer the obvious question, well, what about X, Y, and Z? And, do we want to say we're going to study them? Or do we want to say we're going to study A, B, and C immediately and D, E, and F later on? And I guess I'd like to hear from Emily as to how, she thinks is the best way to handle it.
And I would also add in, just interrupt a little bit. We're also in the midst of a comprehensive review of the statutes, regulations, advisory opinions. And part of that review includes whether they're going to be as product of that legislative proposals as well. So
Additionally,
you could also consider that items that may not make the immediate cut are not necessarily excluded. In fact, they should be part of that broader examination that we're undertaking.
Emily, what do you think?
Yeah, I think last year we communicated it pretty clearly which ones we needed to study more at the commission meeting. And I think there was a document on that we posted, and I think that satisfied, the stakeholders who had proposed it, and they were happy to see some movement on some of the ones that they had proposed. So I think something similar would be fine for this year.
Okay, well, I suggest, but please don't hesitate, if I try to just create a quick summary of this meeting, referring to what I've just said, circulate it in the next, I'm going away for a week on Monday, so I may need another week. But circulate it to the committee, and that in effect would then be what we would propose, before the commission. And then Emily could use that document to draft the appropriate press release. Does that seem the way to go?
Yeah, I don't think we need a press release. I think similar to what we did last year, I could take what you sent, maybe reformat it a little bit, right? And like we've done before with other things. And then we could have that out with the commission meeting, and it could be discussed at the commission meeting. So it'll be online and on our website. I can put it with the legislative agenda website as well, so people could see it.
And we will then eliminate the word tentative in our legislative.
Eliminate tentative, yes.
Well, that's great. And I think this is also the appropriate time to thank Emily and her staff for the terrific job they did in helping us prepare for the public meeting, which I think was very, very successful. So,
Yes.
thank you all. Thank you.
Thank you. Thank you.
Applause. Records to reflect applause.
Any other comments? If not, I promised.
You did it.
Anything else?
I know you're sending us this, so I just wanted to go over the 4 proposals that you had. So the advisory, the first one was the, disclosing if somebody misrepresents that, we're just gonna hold off, right?
Well, we might want to be prepared to, the committee is considering a potential advisory opinion when this is posted, so we're not going to adopt that opinion until the December meeting.
Right, so we're gonna put that on hold, that's gonna stay on the tentative. And the fighting discrimination
We're leaving it, as
That's
is.
gonna be on our, that's gonna stay on
Yeah.
our legislative proposals and, yeah.
I thought the discrimination was going to be on our.
We're not removing what we have on.
Okay.
Question of additional thing.
And then the third one was, the opposed or, you know, to give the position, if we decide to keep that on, because
We're gonna further study.
we're gonna, so that's not on the legislative proposal right now, that's on the
Correct.
study list, okay. And the disclosing fundraiser, lobbyist fundraising, that's also on the study list, but I just wanted to, I thought, yeah, okay, thank you.
Okay. Well, I want to thank also all the members of the staff who helped us do this. And unless there's any further business, I suggest that we end the meeting.
Thank you for sending all that stuff around.
And thank you for this wonderful book that was
Yes.
prepared. I think that is,
I'll let Martha know.
yeah, yeah.
Kate's excellent analysis of both the testimony and the written submission.
Is this gonna be sent by email as well? I mean, I'm happy to have the hard copy. I'm just wondering, so
You,
that,
you should have all of those by email already.
oh, it was,
Yes.
what Emily sent yesterday.
Yeah,
with
same
what's
thing.
everything.
Right.
Except it's broken up nicely.
You want my, I'm not gonna bring the notebook. You want my copy of the actual notebook? The hard copy. Oh, no, I'll take what's inside it, but I don't have to put it in my briefcase.
No, that's, I hear, no, I don't.
We'll recycle it. Martha will please.
Are we officially adjourned?
Well, we did have a motion.
It's adjourned, yeah, I'll move to adjourn,
Second. Any dissent? All those in favor? Thank you very much.
yes.
Wait for the
Take care, everyone. Have a good weekend. Happy Thanksgiving.
holiday.
Our battery is
Oh,
running.
perfect time.